Hi, my name is Jenny Whitmire. I'm here today to go over the step-by-step probate process. Many of our clients, when they come in, they are terrified of the word probate, yet many don't really know what it is or what it entails. So let's demystify the process a little bit. So when your loved one passes away, if they have any assets in their name, they're likely going to go through probate, whether they have a will or they don't have a will. So the first step is the application process. So if you have a will, you're going to be the executor. If you don't have a will, you're going to be the administrator. You'll complete an application to be the executor or to be the administrator, along with an oath, a family tree. You may also need to do some other documents such as a spousal allowance, a bond waiver, or renunciations. It's all kind of case by case. So you'll submit your application, all the documents, and the original will, if there's a will, to the clerk of court. This can take a little while to get appointed, usually about 2 to 8 weeks, depending on the county. But when the clerk appoints you as the personal representative, so the administrator or the executor, they'll issue what's called letters of administration or letters testamentary. So it's called letters, but it's just one piece of paper, and it gives you all of the power that your loved one would have had. So basically, any bank account they had, you have that paper now, so the bank will speak to you about that account. Once the clerk issues the letters, you need to post what's called a notice to creditors in the paper wherever your loved one lived. So this notice to creditors opens up a 90-day window for creditors to file timely claims against the estate. But if they don't file in that 90-day window, you can deny the claim because it's not timely. So I really recommend getting that notice posted as soon as you can. Also, when the clerk issues the letters, it starts another deadline. This is for step 2, called the estate inventory. This deadline is about 3 months after you've been qualified as the executor or the administrator. So the inventory, I like to think of it as a snapshot of everything that your loved one owned on the day they passed away. So if they had a bank account, you'll list the bank account on the inventory. You have to list the value to the penny of that bank account on the day they passed away. And then you have to provide corresponding proof with that. So a bank statement that shows that value. You may also need to get appraisals as well as the bank statements to show the different values. So it can be a little bit of a tedious process, and that's why they give you 3 months. So once you submit the inventory 3 months later, and the notice to creditors has been posted and the creditors window has closed, you'll need to make sure that you've done any personal taxes for your loved one from the year that they were living and any estate taxes. Once all the taxes are settled and there are no claims, then you can move on to phase 3. And this is the accounting phase to kind of wind down the estate and close it. So with the accounting, you look at your inventory and you have everything listed there from the date of death. You have to track everything that comes into the estate and goes out of the estate into the day that you're ready to distribute to the heirs and beneficiaries. This can be a tedious process because it can be a lot of statements depending on how many accounts and what your loved one owned. But we're happy to help you along the way. Once you're ready to close the estate, you distribute the funds to the heirs, they sign receipts, and then we submit that final accounting to the clerk of court. All in all, the process can take over a year many times. So it can be tedious, which I think is why a lot of people are a little scared. And different counties treat things differently. So, you may have to submit something a little bit differently than you thought. But we are here to help, more than happy to help along the process every step.